If you operate a sober living home, one zoning denial, one landlord refusal, or one wave of neighborhood pressure can put the whole home at risk. And here is the part many operators miss. Your issue may not be just a local housing dispute. It can be a federal fair housing issue. And in this video, I'm going to show you how the Federal Fair Housing Act protects sober living homes, where cities and landlords usually cross the line, and what to do the moment that happens. Because if you understand this early, you can protect the home, protect your residents, and respond with much more leverage. The Fair Housing Act is federal civil rights law. It prohibits discrimination in housing based on protected characteristics, including disability. That matters because individuals recovering from substance use disorders are often protected under the law. So when a sober living home is treated differently because of the people who live there, fair housing rights may be implicated. That is the first key point. Sober living is not just a zoning issue. It can be a disability discrimination issue, and that changes the analysis immediately. A lot of operators make the mistake of treating these conflicts like routine local problems. They think this is just a permit issue, or this is just a landlord who is uncomfortable. But if the home is being burdened because the residents are people in recovery, you may be dealing with federal law, not just local politics. That matters because discrimination against sober living rarely comes in a blunt form. Usually it shows up through rules. Maybe a city imposes spacing restrictions. A zoning board uses family definition or occupancy rules to say unrelated people cannot live together. Or a landlord backs out after learning the intended use. Or officials start enforcing rules selectively in a way they do not use against comparable homes. That is the second key point. The Fair Housing Act matters because sober living homes are often pushed out through unequal treatment, not direct statements. And that is exactly where operators need to be sharper. The issue is not just what the city or landlord says. The issue is how the home is being treated and why. If a municipality is singling out recovery housing with restrictions that do not apply the same way to other residential uses, that is a red flag. If a landlord is refusing to rent because the residents are in recovery, that is a red flag. If a rule is being used to block equal housing opportunity for people with disabilities, that is a red flag. And this is where the law becomes practical. The Fair Housing Act can require reasonable accommodations when needed to give people with disabilities an equal opportunity to use and enjoy housing. That does not mean every request wins, but it does mean cities and housing providers cannot say no just because sober living is unpopular, misunderstood, or politically inconvenient. That leads to the third key point. When pushback starts, operators need a clear response framework, not panic, not vague frustration, a framework. First, document everything. Save emails, notices, denials, inspection records, and notes from calls or meetings. Second, identify the actual issue. Ask whether the home is being treated differently because the residents are people in recovery. Ask whether fair housing rights may be implicated. Third, make formal requests in writing. If a reasonable accommodation is needed, request it clearly and directly. Do not rely on hallway conversations or verbal assurances. Fourth, escalate through the proper channel. That might mean an administrative appeal, a fair housing complaint, negotiation through counsel, or litigation, depending on the facts. The point is simple. Do not let discrimination hide inside procedure. A lot of bad decisions are dressed up as normal process. More paperwork, more hearings, more delay, more conditions. But the form of the process does not answer the real question. The real question is whether the home is being denied equal access to housing because of who the residents are. And operators need to keep that question front and center. Now, one important limit. The Fair Housing Act is not a free pass. It does not excuse non-compliance with legitimate health and safety rules. And it does not mean every sober home automatically wins every dispute. But it absolutely does mean this. Cities and landlords cannot target recovery housing with fear-driven restrictions and hide behind neutral language. That is the core principle. And it matters for a bigger reason. When sober living homes are excluded unfairly, this is not just about one address. It reduces access to stable housing for people trying to rebuild their lives. So protecting fair housing rights is not just about defending a property.
It is about protecting access to recovery.
The takeaway is simple. If a sober living home is being treated differently because the residents are people in recovery, you may not just have a zoning problem or a landlord problem. You may have a federal fair housing issue, and the earlier you recognize that, the stronger your position becomes. Subscribe for practical recovery housing guidance that helps you protect, operate, and grow your sober home. Access legal resources and real-world solutions for the issues sober house operators actually face. Vanderburgh Sober Living is a nonprofit organization with a mission to equip our chartered operators with the tools they need to open, strengthen, and scale their sober living homes. If you want deeper support, check the description for Recovery Housing Law and Practice, our practical legal guide to zoning, fire safety, code enforcement, and legal protections for recovery housing.